Welcome to Kaumudy Global. According to a recent survey by the Judicial Commission, 4.5 crore cases in India are pending before various courts. About 75,000 in the Supreme Court and 50 lakh in the 25 High Courts, 4 crore in other lower courts. There are many cases in which the trial has not started and the trial is ongoing. Another interesting thing is that it only takes 324 years to settle existing cases. Recently, a case came before the Supreme Court. The case first came up in the Allahabad High Court when over 1,83,000 appeal petitions were pending before it. Following this, the Supreme Court asked other courts to use plea bargaining effectively in such situations. These things were revealed by retired DGP Rishiraj Singh. So what exactly is plea bargaining? The Plea Bargaining Act was enacted in India in 2006 by Parliament by amending CRPC 265A to 265L. As per the Act, a person who has committed more than one offence will have to accept the case with least punishment and bargain for less penalty and can approach the prosecution and discuss a lesser sentence. Meanwhile, there are certain criteria for conducting plea bargaining. Number 1. Only the offender can do plea bargaining. Number 2. The offender should approach the court for this. Number 3. There is some limitation to doing plea bargaining. Plea bargaining cannot be used for crimes of treason, death penalty, life imprisonment or imprisonment for more than 7 years. Plea bargaining is also not possible for POCSO cases and atrocities against women. Number 4. In India, when the number of cases punishable by less than 7 years is more than 2 crores, cases can be settled quickly if plea bargaining is used properly. Number 5. At the time of approaching the court, the accused has to give an affidavit that he has pleaded guilty at his own will. Number 6. The offender must inform the opposing attorney, police and plaintiff in writing that such an application has been made with the court. Number 7. All the above should be done in front of the judge in camera and it does not need to be held in public courtrooms. Number 8. Once all the formalities are completed, the court will ask the government to sit down with the prosecutor, the investigating officer and the plaintiff in the case and you can make a decision. You can also try to settle by paying compensation. After this, they have to inform the court when they come to a decision. Thus, the court can commute the sentence of the offender and in some cases reduce the sentence to 1/4. Number 9. Plea bargaining can speed up the trial process. This is the best way to settle about 20 million cases. Number 10. 62% of convicts in Indian jails have not even started their trials. The number of under-trial cases in India is 80,000 in Uttar Pradesh, 45,000 in Bihar and 32,000 in Madhya Pradesh. These defendants could be released from prison with a shorter sentence if they use plea bargaining into the under-trial cases. Number 11. Most of the jails in India are full. This condition can be resolved by plea bargaining. At the same time, it is imperative that courts take into account the misuse of plea bargaining. About 2 crore cases can be settled in India through plea bargaining alone. Many cases in the United States are settled with the same. I'm Neha signing out. If you liked the video, please subscribe to our channel and hit the bell icon to get the latest updates.